Hello everyone, happy Valentine's Day. Daniel Sherman here. Again, I am driving. I'm on the road to my son's academic team meet. Wanted to talk today about grand juries and indictments. You may have heard in the news, Senator Mark Kelly and a few others, the case was presented in front of the grand jury. The grand jury did not issue an indictment, and so that is essentially the end of the case. So the question is, what is a grand jury and what is an indictment? So the section regarding grand juries is actually found in the Fifth Amendment of the U.S. Constitution. But we must remember the U.S. Constitution applies only to the federal governments, at least initially when it was written. It says Congress shall make no law, and then says what it has to say. Through the years, however, the Supreme Court has applied the Bill of Rights and other amendments to the Constitution to the states. So that's been applied through the 14th Amendment Equal Protection and Due Process Clause. Essentially what that means is not only can the federal government not, enter your house without a warrant, it means the state governments cannot enter your house without a warrant as well, regardless of whatever the state law is. So the Bill of Rights protects us not just from the federal government, but also the state government. With the exception of, the only exception in the Bill of Rights is grand juries. The grand jury section in the Fifth Amendment does not apply to the states. The Supreme Court at least hasn't made that application. Many states, including Kentucky, do have it in their constitution regarding grand juries. So what is a grand jury? Well, first, there are two kinds of juries. There's a grand jury and there's a petit jury. A petit jury is exactly what you think it is. It's a normal jury that makes a decision on criminal cases, not guilty or guilty, and in civil cases makes determinations on liability, and then monetary judgments and things like that. A grand jury, though, is for a very specific purpose, and that purpose is to issue an indictment. And a grand jury is typically made up between 12 and 18 individuals. They will meet every so often, and based on a probable cause determination, will issue a piece of paper. That piece of paper is called an indictment. An indictment, at least in Kentucky, formally charges somebody with a felony offense. In Kentucky, you do have a constitutional right to have your case submitted to the grand jury. If it is a felony, you can waive that right, though. There are certain exceptions, and I'll go through that later when I talk about arraignments. But for today's purposes, a grand jury issues an indictment. Now, what is presented at the grand jury level to issue an indictment? Typically, it is going to be in our state, the Commonwealth's attorney. Some other states, maybe the district attorney. And then for the federal government, you're looking at the U.S. attorney or assistant U.S. attorneys will submit it in front of the grand jury. Most of the time, that's the only evidence that's submitted, and grand juries do have the ability to collect evidence, issue subpoenas, things like that. However, Kentucky does allow for a defendant to present evidence, including his or her own testimony at a grand jury. It does not happen very often, but there is a procedure. It is in the criminal rules. Essentially, what a defendant has to do is notify the Commonwealth attorney in writing prior to the meeting of the grand jury and state his intention to present evidence or present himself in front of the grand jury. Then the Commonwealth attorney has to notify the defendant of the date, time, and the location that the grand jury is meeting to hear his or her case, and that defendant can show up with his evidence or any other witnesses and sit in front of the grand jury. However, it is not a right. The grand jury does not have to hear from somebody. I actually had a case in Logan County about 15 years ago. My client wanted to testify in front of the grand jury. We did the procedure. The grand jury said, nope, we don't want to hear from you, and that's the end of it. The grand jury went issued an indictment. So, again, an indictment is just a piece of paper formally charging someone with a felony. Sometimes you'll have misdemeanors and violations and DUIs on indictments. They can, but an indictment usually requires at least, in Kentucky, requires a felony for an actual indictment. Now, there are certain things a grand jury can do. Grand jury can do a number of things. Number one, they can issue an indictment as charged. They can issue an indictment to a lesser included. So, for instance, if it's trafficking in the first degree, they can issue an indictment to trafficking in the second degree. They can remand the case, which means, hey, we want it to go back to district court for consideration, or we want to go back to district court for new charges or consider on a misdemeanor. The grand jury can take no action and consider it at the next session of the grand jury, or the grand jury can return what's called a no true bill. No true bill just means any charges submitted to them, they've decided there was insufficient evidence, insufficient probable cause to issue an indictment. So that's how the grand jury and the indictment works. And again, an indictment's nothing but a piece of paper charging somebody with a crime. It's a probable cause determination is all it is. And actually, in cases, when you try cases, the Commonwealth attorney will read the indictment in his opening statement. That's a requirement. But the judge instructs the jury that the fact that there is an indictment is not evidence against the defendant and should not be given any weight. So that's how an indictment applies to a trial. It just simply sets forth the charges, typically going to be felonies in the state of Kentucky and again federally. Again, it's not a constitutional right in many states. In Kentucky, it is. So that is, in sum, the grand jury process and what an indictment is.